Ladies and gentlemen, welcome back to another legal breaking reporting video analysis update. We have a new breaking reporting as it relates to the ongoing lawsuit between the state of Illinois and the city of Chicago against the Trump administration to legally stop the authoritarian dictator move of Trump to illegally assert power over Illinois' National Guard and approximately 300 or so National Guard troops. This lawsuit is in particular similar to cases, an original case from Oregon that was filed and won by state officials. Let's get into the reporting. Ladies and gentlemen, the reporting begins as of October 6, 2025, the state of Illinois and the city of Chicago have filed a federal lawsuit against Trump and his illegal administration. Ladies and gentlemen, my editorial edition. To block the deployment of the National Guard to the state, a federal judge in Illinois has declined to immediately block the deployment, but has ordered the Trump administration to respond to the lawsuit by Wednesday, October 8. Ladies and gentlemen, let's get into the details of this excruciating breaking lawsuit. We first have the details of the filing and the location of the court hearing. The federal lawsuit was filed on Monday, October 6th. Today, ladies and gentlemen, in federal court, it follows a similar lawsuit filed by Oregon, as I mentioned at the beginning of the video, ladies and gentlemen, and legal breaking reporting, where a federal judge already blocked the deployment of federalized Guard members. Plaintiffs' argument, ladies and gentlemen, is where we are going to be, what we are going to be reading next and getting into. Illinois and Chicago argue that the Trump administration is unlawfully using the military to target cities with different political leaderships. According to Illinois Attorney General Kwame Raiola, Raoul, first name spelled Kwame, deploying troops to states that don't share the president's political views is an overreach of authority. Ladies and gentlemen, we are now getting into the details of this unlawful deployment. The suit aims to block the federalization of the Illinois National Guard and to prevent Guard members from other states, such as Texas, from being sent to Illinois. Ladies and gentlemen, we are now getting into the reasoning of the defendants. In this case, the Trump administration. The White House stated that the deployment was authorized in response to ongoing violent riots and lawlessness in Chicago. Trump, I'm sorry, son, but you're the only one that's acting lawless. So before you even want to say it's in response to lawlessness, check yourself, you moronic doofus. In Chicago. Ladies and gentlemen, we are now getting into the decision of Judge April Perry's. U.S. District Judge April Perry did not grant an immediate block on the deployment. Instead, the judge set a deadline for the Trump administration to file a response by 11:59 p.m. on Wednesday, October 8th, and scheduled a hearing for October 9th. Ladies and gentlemen, we are getting into the background on other recent cases, so let's get into it. This is one of several legal disputes between the Trump administration and Illinois and Chicago in 2025. In February 2025, the DOJ sued Illinois, Chicago, and Cook County over sanctuary city policies, claiming they obstructed federal immigration enforcement. That is number one, ladies and gentlemen. Now, number two, in September 2025, the DOJ filed a complaint challenging Illinois' laws that grant in-state tuition and scholarships to non-citizens, arguing this discriminates against U.S. citizens. That was the weakest case ever. Really? An argument based off of discrimination against U.S. citizens? No. Nice try, Donald Trump. You guys, I bet you will lose that case, or probably have already lost the case. Illinois and Chicago have recently filed a lawsuit against the Trump administration to block the federalization and deployment of the National Guard to the city. A judge from the federal judiciary, ladies and gentlemen, my editorial edition, is reviewing the case and declined to immediately block the deployment. Again, ladies and gentlemen, in case you guys didn't hear me, let's run through the parties. Ladies and gentlemen, the parties. The lawsuit was filed by the state of Illinois, represented by Attorney General Kwame Raoul, and the city of Chicago against President Donald Trump. The Department of Homeland Security, the Department of Defense, and other federal officials. this lawsuit aims to stop. In case you guys didn't hear me, I'm going through it one more time. The Trump administration from deploying federalized National Guard troops to Chicago, arguing that the action is illegal and unconstitutional. Illinois alleges the administration can only federalize the National Guard in specific circumstances, such as invasion or rebellion, which do not apply here. Ladies and gentlemen, this is true. Recent arrests, ladies and gentlemen, events leading to the suit is where we're getting to next. In early October 2025, the Trump administration authorized the federalization and deployment of 300 National Guard members and 400 Texas National Guard members to Chicago. The lawsuit came shortly after a federal judge in Oregon temporarily blocked the deployment of the Guard to Portland, which Illinois and Chicago cited as a precedent. On August 6, 2025, U.S. District Judge April Perry ladies and gentlemen, heard arguments, but did not immediately issue a temporary restraining order to block the deployment. The judge gave the administration until the end of the day on Wednesday to file a response and scheduled a hearing for Thursday, October 9th. Illinois and Chicago officials argue that the deployment is politically motivated and an attempt to unlawfully occupy and incite Democratic-led cities that do not support the president's policies. Ladies and gentlemen, let's get into other related Illinois lawsuits against the Trump administration. The National Guard case is the latest in a series of lawsuits filed by Illinois against the Trump federal administration. Other recent litigation include challenging the election laws. In a series of ladies and gentlemen, challenging election rules, the U.S. Supreme Court is set to hear arguments in a separate case concerning Illinois' election law. Ladies and gentlemen, rule. Which allows mail-in ballots to be counted up to 14 days after Election Day. A group of Republicans is challenging the rule, arguing it violates federal election law. Ladies and gentlemen, disputes over funding is where we're going to be reading next. Illinois Attorney General Quame Rowell, OW. Sorry, I was. Excuse me, OUL. Sorry, I was trying to say a W instead of an A. RAOUL is how the last name, and KWAME is how the last first name is spelled. Has also sued the Trump administration over the withholding of federal funds, such as money for crime victims related to the state's immigration enforcement policies. Illinois and Chicago have defended the state laws that limit cooperation with federal civil servants. Federal civil immigration enforcement, which the U.S. Department of Justice has challenged in court, obviously. Ladies and gentlemen, just to reiterate again, federal judge April Perry did not deny the temporary restraining order outright in the lawsuit filed by Illinois and Chicago against the federal government on October 6, 2025 today. Instead, ladies and gentlemen, she deferred a decision on the TRO and instructed the Department of Justice to respond to the request within 2 days. Ladies and gentlemen, let's get into the context of that. The lawsuit was filed after President Trump authorized the deployment of the National Guard troops to Chicago. The state of Illinois and the city of Chicago sued the Trump administration, arguing that the federal government was overstepping its authority. The lawsuit follows a similar case again in Oregon, where a federal judge did block the federalization and deployment of National Guard troops to that state. Judge Perry's directive, ladies and gentlemen, is where we're getting into next. Judge Perry did not immediately block the deployment, but scheduled oral arguments for the following Thursday to further consider the matter. The federal government indicated that the National Guard troops could be arriving in Chicago as early as Tuesday, meaning that a decision on the restraining order would come after the deployment had potentially begun. Ladies and gentlemen, we will be getting into the judge's actions. Rather than immediately granting or denying the TRO, Judge Perry gave the Department of Justice a deadline to respond to the lawsuit again by Thursday, ladies and gentlemen, October 9th. This is a standard legal procedure to ensure all parties are heard before a significant legal order is made. Ladies and gentlemen, next we're getting into pending court dates. After Judge Perry's October 6th order, the court awaited the Department of Justice's response by October 9th. And, ladies and gentlemen, finally, in summary, but last but not least, Judge Perry did not deny the TRO request. What she did, ladies and gentlemen, is simply did not issue an immediate ruling and followed standard court procedure by giving the opposing side an opportunity to respond before making a decision. Ladies and gentlemen, finally, in this legal breaking update, the lawsuit asks the court to stop the federalization of the Illinois National Guard and deployment of troops from other states into Illinois. The plaintiffs argue that a president's authority to federalize a state's National Guard is limited to cases of invasion or rebellion, which they contend are not present in Illinois. This legal action follows a similar case in Oregon, ladies and gentlemen, where a federal judge blocked a comparable deployment. Illinois Governor J.B. Pritzker has criticized the administration's move, referring to it as Trump's invasion. A Pentagon memo suggested the troops would protect federal property and personnel.